The last time your landlord kept your security deposit, you probably just accepted it. You maybe argued a little, got nowhere, and moved on. But here is what nobody told you. In most states, there is a specific law that entitles you to get every single dollar back, plus penalties on top, and landlords are counting on you to never find out it exists. Stay with me because by the end of this video you will know this law better than most landlords do. And I am going to give you the exact written demand that forces them to pay. Security deposits are one of the biggest quiet financial drains in the country. Renters lose an estimated $3 billion every year to deposits that were never legally theirs to lose. That number is not an accident. It is the result of a system that works perfectly, as long as you stay ignorant of your rights. Here is how it has worked for decades. You move out. The landlord sends you a vague letter or just goes silent. Maybe they charge you for carpet cleaning, paint touch-ups, a broken blind you have no memory of breaking. You do not really know the rules, the clock is ticking on your new place, and fighting feels like more trouble than the money is worth. So you walk away. But here is the thing that should stop you cold. Every state in the country has a security deposit return statute. Every single one. These laws set hard deadlines, require written itemized documentation, and in most states, failure to follow them does not just cost the landlord your deposit. It costs them double or triple the original amount, paid directly to you. Write this down because these two things are what most renters never know. First, the deadline. Depending on your state, your landlord has between 14 and 30 days after you vacate to return your full deposit or send you a written, itemized list of deductions with receipts. In states like California and Texas, that window is 21 days. In New York, 14. In Florida, 15 to 30 depending on whether they contest. If they miss that deadline, in many states the law presumes the entire deposit is owed back to you regardless of what damage actually occurred. Second, and this is the one that changes everything, normal wear and tear is never deductible. Ever. Landlords are legally prohibited from charging you for the natural aging of their property. Carpet that wore thin over 2 years of normal use is not your bill. Paint that faded is not your bill. A slow-draining faucet from mineral buildup is not your bill. Only damage you actually caused beyond reasonable use can legally come out of your deposit. And most landlords charge for wear and tear constantly, knowing that almost no one pushes back. Now here is the trap, and this is where billions of dollars disappear every year. When a landlord sends you a deduction letter, many of them will include a check for a partial amount. And that check will sometimes have language printed on it or in the accompanying letter that says something like, "Acceptance of this payment constitutes full satisfaction of deposit obligations." If you cash that check without responding in writing, in many states you have just signed away your legal right to challenge the rest. That partial check is not a gesture. It is a legal tripwire, and they know it. Do not cash any partial deposit check until you have sent a written response disputing the remaining balance. Keep that check. Document it. But do not deposit it until you understand your state's specific rules around accord and satisfaction. Now let us go deeper, because the scope of what you can recover is larger than most people realize. If your landlord charged you for professional cleaning when you left the place in the same general condition you received it, that is likely an illegal deduction. If they charged for painting an entire room because of one small scuff, that is illegal. If they hired their own maintenance company at inflated rates without providing receipts, that is likely illegal. Any deduction that cannot be supported by a dated invoice or receipt can be challenged. Here is the hard deadline you need to know. In most states, the window to file a small claims case over a security deposit is between 1 and 3 years from the date you vacated. Small claims court does not require a lawyer, fees are usually under $100, and judges in these cases frequently side with tenants when the landlord failed to follow the statutory process, even when actual damage exists. Now I promised you the exact written demand that puts landlords on notice. Here is what you send via email with a return receipt or certified mail within 5 business days of receiving any partial or no refund. Write this down or screenshot the screen. I am writing to formally demand the return of my security deposit in the amount of blank dollars for the property at blank address. Vacated on blank date. You have failed to provide a complete itemized statement with supporting receipts within the statutory deadline required under state law. Pursuant to state security deposit statute, I am entitled to the full return of my deposit and potentially additional damages for non-compliance. If I do not receive full restitution within 14 days of this notice, I will file a complaint with the State Attorney General's Tenant Protection Division and pursue all available remedies in small claims court. That letter does three things simultaneously. It signals that you know the law, creates a paper trail, and it often resolves the dispute before it ever reaches a courtroom, because landlords who have violated the statute know they are exposed. If the letter does not work, your next step is your State Attorney General's office. Most states have a tenant protection or consumer protection division that accepts complaints against landlords for security deposit violations. These complaints cost you nothing to file, and a formal state inquiry carries real weight, especially with landlords who manage multiple properties and cannot afford regulatory scrutiny. One honest caveat before we wrap up. This video covers the deposit return process, and while these rights are strong, they are not infinite. If you did cause genuine damage beyond normal wear and tear, a landlord with proper documentation can legally deduct for it. This is not a guide to disputing legitimate charges. It is a guide to knowing the difference between legal deductions and illegal ones, and understanding that you have actual legal tools when a landlord crosses that line. Here is the full picture in 5 points. 1. Every state has a hard deadline for deposit return, typically 14 to 30 days. If they miss it, you likely win by default. 2. Wear and tear is never your financial responsibility. Only documented damage beyond normal use is deductible. 3. Do not cash a partial check without responding in writing first. It can be used to close out your legal claim. 4. Every deduction requires a dated receipt or invoice. No documentation means no legal deduction. 5. If they refuse to comply, send the written demand, then file in small claims court and report them to the State Attorney General. And the phrase you send, "I am formally demanding return of my deposit and will pursue all statutory remedies including double damages and attorney fees if not resolved within 14 days. You paid that deposit. You earned it back. Now you have the law, the deadline, the demand letter, and the escalation path. The only thing left is whether you use it.